When Harriet, Holmes and I were young, we wanted to be DJs. We loved the idea of dressing up in silly outfits, talking a lot, and also counting down the charts. We didn't make it as DJs, but we did find another way to dress up and talk a lot. But today, Pop Pickers, today we get to realise the dream of counting down the charts. And we'll be counting down the top 5 property cases of the past legal year. Starting straight in at number 5, we've got a decision of the Upper Tribunal Lands Chamber in Cornerstone against the University of Arts.
Jonathan, is
Yes.
that the case concerning the site in Elephant and Castle, the one that's being redeveloped?
Yes.
Is it the one in which Judge Elizabeth Cook considers the public benefit test under para 21.3 of the Code?
Yes, it was an application for the tribunal to impose an agreement under paragraph 20 of the Code, which says that one of the conditions for giving Code rights under paragraph 20 is where the public benefit likely to result from the making of the order outweighs the prejudice to the relevant person. And this was the first case to consider the balance between those two countervailing factors.
Very interesting. So it was kind of a clash of the titans, the public benefit in the mobile phone signal 2, 3, 4 and possibly 5G services one day versus the prejudice to the University of Arts. But who won out?
Well, do you know what, Pop Pickers? It was the University of Arts. The prejudice to them was held to be greater than the public benefit of a new electronic communication site in Elephant and Castle. Do you know why? Well, the University of Arts said that if the mast and all the kit was put on the roof, then it may not be able to deliver vacant possession to the developer under its contract with that third-party developer, putting it in breach of contract or in a position of having to litigate to remove Cornerstone.
That's pretty interesting. So basically, very high prejudice will outweigh the public benefit of a new site.
Exactly. And that's number 5 in the charts of the top 5 cases of the past legal year. And number 4, we've got a decision of Peter Knox QC, sitting as a deputy in the High Court, in the case of Beaumont Business Centres against Florala Properties. What's this one about, Harriet?
Well, it's a rights of light case. It caused quite a stir when it came out because the court determined that an injunction requiring the developer to cut back the development should be granted. Beaumont was in the business of letting badly lit serviced offices from a site in Moorgate, although high-end, I should say. They said Florala's building in a light well next door infringed their rights to light over that well.
Sounds like the court agreed.
Well, yes, it did. There are a couple of interesting points come out of the decision. The first is sort of on establishing the nuisance. The question was whether the reduction in light to Beaumont's premises made them substantially less comfortable for the beneficial use and occupation for the letting of serviced offices. Florala said only a small amount of loss or rental or capital should not be regarded as substantial, i.e. no nuisance. But the court held that in practice, the claimant had to show that it was likely to suffer a loss of rental income over the balance of its term in an amount which was more than trifling or de minimis. And on the facts of that case, Beaumont could. So the actual nuisance was established.
What about if the development could be shown to increase letting values?
Well, that's an interesting point. Definitely harder to see how an actionable nuisance would arise in those circumstances based on Mr. Knox's reasoning. The second point of interest is that the court looked at the evidential worth of that century-old method for measuring light, the Waldron method. It's been much maligned, particularly in the Irish courts, but Mr. Knox QC took the view that whilst it shouldn't be ignored, it's only a starting point, so it's still relevant. But other more modern analyses, such as radiance based on climate-based data and human response analyses, might be relevant. So that's number 4, Jonathan.
And in at number 3, we've got a decision of Mrs. Justice Falk in Winfinch against Natural Resources Body for Wales. You want to tell us what that's all about, Harriet?
Yeah, so it's the Mines and Minerals case. It was a claim by trustees who said they were successors to the lords of 2 manors in mid-Wales.
Right.
Basically, the trustees said that they'd retained the corporeal estate in everything beneath a thin layer of surface soil, including the mudstone, in about 40 parcels of land in mid-Wales, either by express exceptions in conveyances or when the land was allotted under enclosure awards pursuant to a Private Enclosure Act of 1816. Why did that matter, I hear you ask? Well, Natural Resources, the devolved Forestry Commission, had been digging up the mudstone and the interbedded sandstone to build roads and forestry infrastructure. The trustees, as claimants, said that was a trespass and conversion.
Isn't mudstone really cheap, sort of compressed mud?
How very astute of you, Jonathan. Funnily enough, there was some argument about that. Anyway, the court held that whatever corporeal estate in minerals the trustees held, it didn't extend to the mudstone and interbedded sandstone. But the judge said that if she was wrong about that, natural resources had in any event acquired title by adverse possession to so much of the subsurface as might be required for activities as a surface owner. Might sound dull to some, but there are a lot of these claims around. You're acting in some of them, aren't you, Jonathan?
Yes.
Some had been awaiting this decision, and there is plenty in the judgment about the meaning and effect of commonly encountered terms in enclosure acts, including the saving of rights to the lord of the manor, and it's the first modern application of adverse possession principles to subsurface estates. The trustees are seeking leave to appeal, Jonathan. That's hot off the press. So I'm not going to say much more about it.
Thank you. That's number 3. And in at number 2, we are climbing the judicial ladder to a decision of the Court of Appeal in Dillon against Barclays Bank, where Mrs. Dillon had a right to buy her home, which was fraudulently taken over by her husband, the right to buy, that is. And he pushed the ownership of the property into a corporate vehicle, which he then charged to Barclays Bank. When her husband was convicted of the fraud and the corporate vehicle was dissolved, the property vested back in Mrs. Dillon's name, subject to the charge to Barclays Bank, which she then sought to remove under Schedule 4 to the 2002 Act on the basis to the charge to Barclays was a mistake.
Did she win?
No, pot pickers, she failed. And she failed on the basis that there were exceptional circumstances. It was exceptional because she had only ever been a secure tenant. She never actually owned the property. Although she had the right to buy, she had not contributed to the purchase. She could not have bought it without having to sell it immediately.
But where did the fraud come into it then?
Well, pot pickers, it was thought that she should not be allowed to benefit from her husband's fraud by owning it free of charge. That would be a windfall. And the case is also interesting in saying how the right of indemnity segues into the right to rectification.
It doesn't, does it?
No, absolutely not. It's irrelevant to it and should be considered entirely separately. Those things stand completely separate from one another. So
that's our number 2. Now, Jonathan, let's check out the charts.
Excellent. At number 5, we have
the decision of Judge Cook and Mr. Trott in the Upper Tribunal, Cornerstone and University of Arts. In at number 4, we have the decision of Peter Knox QC, sitting as a Deputy of the High Court in Beaumont Business Centres and Florala Properties, a case in which our very own Mark Wynne-Finch QC appeared.
Now, at number 3, we've got the decision of Mrs. Justice Fulk, sitting in Chancery in Winfinch against Natural Resources Body for Wales. It was a Chambers triple hatter with Fenner Moran QC for the claimants against Mark Wynne-Finch, again, this time leading you, Harriet. And at number 2, we've got Dillon and Barclays Bank, the decision of the Court of Appeal with Lord Justice Coulson delivering the judgment of the court.
So that brings us to number 1, our top of the charts. And it's a decision of the Supreme Court in the case of Duval and 11-13 Randolph Crescent, in which our very own Joanne Wicks QC and Emma Murphy appeared for the appellant. Take it away, Jonathan.
Absolutely. So this was where a building, which used to be 2 mid-terraced houses, was now 9 flats and had a freehold, which was owned by a company of which the lessees were shareholders. Very, very common in London. And clause 319 of the leases was a mutual enforceability of covenants clause. The landlord covenanted with each tenant that all other flat leases would contain covenants of a similar nature to those that the tenant was giving, and then at the request of the tenant, and subject to provision of security for costs, the landlord would enforce the provision given by the other flat owners. And one tenant, Mrs. Winfield, wanted to do works to remove a load-bearing wall, and that was contrary to the alterations covenant. She applied for a license to the landlord, which the landlord wanted to grant. But another tenant, Mr. Duval, or Dr. Duval, said that clause 319 didn't allow that. And did the Supreme Court agree with Dr. Duval? Harriet?
It did.
It did.
It did.
It did, even though Mrs. Winfield hadn't given security for costs. And therefore, the standing of a mutual enforceability covenant is there, and, and that's the end of our rundown.